Welcome to the Courtroom Club. Today we're doing a deep dive into something we see all the time here at Jonker Vorster Attorneys. It's a really critical bit of South African employment law.
That's right. We're talking about restraint of trade clauses in employment contracts.
Exactly. And whether you're running a business or you're an employee signing on the dotted line, this is, well, it's pretty crucial stuff to understand.
Absolutely. It affects our clients, daily business owners wanting to protect what they've built, employees figuring out their next steps. So our goal today really is to unpack these clauses. What are they? Are they actually enforceable? And what do you as an employer need to consider to use them properly and fairly?
And we're drawing this directly from our firm's experience, right? From the guidance we provide day in, day out.
Precisely. This is based on our practical work here at Jonker Vorster Attorneys.
Okay, great. So let's start right at the beginning. For anyone maybe less familiar, what is a restraint of trade clause in the South African context?
Sure. So in simple terms, it's a part of the employment contract where an employee agrees that after they leave the job, they won't do certain things that could compete with their former employer.
Like setting boundaries for after you leave?
Kind of, yeah. Professional boundaries for a set period. It limits their competitive activities post-employment.
Okay. And what kinds of activities are we typically talking about? What do we usually see restricted?
Well, based on what we draft and review here, the common ones are things like preventing the ex-employee from jumping straight to a direct competitor for a while,
Right.
or starting up their own business that does exactly the same thing in the same market. Also, crucially, trying to lure away clients or even former colleagues.
Ah, the poaching aspect.
Exactly. And perhaps the most fundamental one, using confidential information or trade secrets they learned while working there. That's a big one for us and our clients.
It definitely sounds like something businesses would need to protect themselves. But I can also see how it could really restrict someone's career path.
It's a definite balancing act. South African law generally says, look, if you freely signed a contract, you should stick to it. That's the starting point.
Pacta sunt servanda, as they say.
Right. But with restraints of trade, it's not quite that simple. There's a big but. An employee can always argue that the clause is unreasonable, and if it is, the courts won't enforce it.
Okay, so that's the key, reasonableness. If an employee challenges it, what do the courts actually look at to decide if it's fair or not?
They weigh up several factors, but there are four main ones we always focus on with our clients. First, does the employer have a real protectable interest?
A protectable interest. What does that mean in practice? Is it just about not wanting competition?
No, it has to be more than that. It's about protecting specific, legitimate business assets, things that genuinely belong to the business and deserve protection.
Like what? Can you give some examples?
Sure. Think about trade secrets, maybe a unique manufacturing process, a secret recipe, proprietary software code. That's clearly protectable. Then there are customer connections or client lists, especially where the employee built strong relationships using the employer's resources and time.
Right, the goodwill built up.
Exactly. And sometimes if the employer invested heavily in very specialized training for that employee, training that goes way beyond the industry norm, that could potentially count too.
Got it. So the employer needs a solid reason, something specific they're shielding. What's the second factor?
The second is the reasonableness of the restraint itself in terms of its duration and its scope.
How long it lasts and what it stops you from doing.
Precisely. The courts are very aware that people need to work, earn a living. So the restriction can't be so broad or last so long that it unfairly stops someone from finding any suitable job in their field.
So a clause saying you can't work in IT anywhere in the world for 10 years, probably not going to fly.
Highly unlikely. That sounds excessive on the face of it. The duration needs to be justifiable, linked directly to protecting that interest we just talked about.
Yeah.
And the scope, what activities are barred, must also be reasonable.
Okay. And the third element.
That's the geographical area. Where does the restraint apply? It generally needs to be relevant to where the employer actually operates.
So if a business only operates in Gauteng, trying to enforce a restraint across all of South Africa or even internationally.
That would likely be seen as unreasonable unless there's a very specific, demonstrable reason why such a wide area is necessary to protect their interest. It needs to match the business footprint.
Makes sense. And the fourth factor?
The fourth one is public interest. The courts step back and look at the bigger picture. Is enforcing this restraint bad for competition overall? Does it risk creating unemployment for skilled people unnecessarily?
So broader economic considerations.
Yes. And, what we're seeing in recent cases, and we advise clients on this constantly, is that courts are increasingly hesitant to enforce very broad restraints if the employer can't show real substantial potential harm. Just saying they might compete often isn't enough anymore.
Okay, this is really helpful. So let's switch hats. We're Jonker Vorster Attorneys advising an employer. They want to include a restraint clause. What are the absolute must-dos to make it as enforceable as possible?
Right. Based on our experience helping clients draft these, number one is absolute clarity. Define the scope meticulously.
No vagueness.
Zero vagueness. Be precise. What exact activities are restricted? Which specific industries or types of roles? Don't just say competitor. Name them or define them clearly. And obviously state the exact duration and the precise geographical boundaries. Ambiguity is the enemy here.
Crystal clear. What else?
Second, get the duration and geographic limits right. They must be reasonable.
And what's reasonable? Is there a rule of thumb?
There's no strict legal maximum, but look, we generally tell clients that anything over 2 years is going to attract serious scrutiny. You'd need a very compelling reason for it.
Okay.
And geographically, as we said, keep it relevant to your actual business operations. A nationwide restraint for a local bakery makes no sense, right? It's a red flag for unreasonableness.
Got it. Keep it tailored. What's a third key element?
The third is having a clear, solid justification for the restraint. You need to be able to point to why it's necessary. What specific protectable interest is it safeguarding?
So linking it back to that first factor.
Exactly. If it's confidential information, describe its nature. If it's trade secrets, explain why they're valuable and secret. If it's client relationships, show the investment made. Without that clear link, that rationale, the clause is vulnerable.
So it's not just putting the clause in, it's being able to back it up.
Absolutely. You need to demonstrate the why.
Okay, so from our firm's perspective, Jonker Vorster Attorneys, what practical advice do we give employers to really boost enforceability?
Well, reinforcing those points. First, tailor the scope. No boilerplate clauses. Make it specific to that employee's role and access. Second, limit the duration. Ask yourself, what's the minimum time needed to reasonably protect our interests? Don't overreach. Third, be explicit about the confidential information or relationships being protected. Spell it out in the contract or related documents if possible.
And record keeping.
Yes, definitely. We advise clients to keep records justifying why this particular restraint was included for this employee. Notes from discussions, role profiles showing access to sensitive data, etc.
Build the case internally, essentially.
Sort of. And finally, don't just file it and forget it. Review these clauses regularly. Businesses change, roles change, markets change. Does the restraint still make sense? Is it still reasonable? That ongoing review is important.
Good practical tips.
Yeah.
Now, conversely, what are the common traps employers fall into that make these clauses unenforceable? Where do things go wrong?
We see a few common pitfalls, unfortunately. The biggest one is probably overly broad restrictions. Trying to stop someone working in an entire industry anywhere in any capacity. That's usually doomed.
Too wide.
Way too wide. Another is, as we've hammered home, excessive duration. Going for 3, 4, 5 years without exceptional justification.
The time factor again.
Always. And maybe the most critical mistake is a lack of proof of potential harm. If you go to court, you need to show how this ex-employee working for a competitor or starting their own thing could actually damage your protectable interests. If you can't demonstrate that potential harm convincingly, the court will likely say, well, what are we enforcing this for?
So it needs to be a real threat, not just a theoretical one.
Exactly. A demonstrable risk to a legitimate interest.
Okay. Let's imagine the worst happens from the employer's view.
Hmm?
They believe a former employee is breaching a valid restraint. What legal steps can they take?
The first step is usually practical, not court-based. Send a formal letter of demand.
A lawyer's letter.
Yes, from us or another attorney, setting out the alleged breach, referencing the clause, and demanding they stop the prohibited activity. Sometimes that's enough.
And if it's not?
Then you might need to go to court. The main remedy sought is usually an interdict. That's an urgent court order basically telling the employee to stop what they're doing immediately.
Like a cease and desist order from the court.
Precisely. And if the business can prove it's already suffered actual quantifiable financial losses because of the breach.
Lost profits, perhaps?
Maybe lost clients, lost contracts, yes. Then they could also potentially sue for financial damages. But, and this is crucial, all of this depends on the restraint clause being enforceable in the first place. If the court finds the clause unreasonable, then these options fall away.
Right, the enforceability underpins everything.
Everything.
This has been really thorough. Maybe we can quickly run through some FAQs, the kind of questions we get all the time at the firm about restraints.
Good idea. Fire away.
Okay, first one. What's the basic purpose again?
Simple. Protecting legitimate business interests, trade secrets, client connections, specialized knowledge, not just stopping competition.
Enforceability, always enforceable.
No. Only if it's reasonable based on those factors. Protectable interest, scope, duration, geography, and public interest.
Duration limits, is there a hard cap?
No strict legal maximum, but practically speaking, anything over 2 years needs very strong justification to be considered reasonable by South African courts.
Can an employee challenge it?
Absolutely. They have the right to argue it's unreasonable and therefore unenforceable.
And finally, consequences of ignoring one, if it is enforceable.
Potential legal action, getting an interdict forcing you to stop, possibly being sued for damages if the employer suffered losses. But again, only if the restraint holds up in court.
Perfect summary.
Yeah.
So pulling all this together, what's the main takeaway for our listeners today from this deep dive?
I think the key message from our perspective at Jonker Vorster Attorneys is this. Restraint of trade clauses are definitely a valid tool for businesses in South Africa. They serve an important purpose. But they absolutely must be drafted with care. They need to be specific, narrowly focused, and genuinely reasonable in terms of time and scope to stand a chance of being enforced by our courts. It's all about justifying the restriction.
It really comes back to that balance, doesn't it? Protecting your business assets while being fair to the employee's right to work.
That's the crux of it. And we believe having this clear understanding is vital for everyone involved in the South African business community, employers and employees alike.
Absolutely. And of course, if you listening need any help with drafting these clauses, reviewing ones you've been given, or dealing with a potential breach, please do get in touch with us here at Jonker Vorster Attorneys. That's what we're here for.
Definitely. And maybe a final thought to leave you with. Take a look at any restraint clauses that affect you, whether you're the employer or the employee. Ask yourself, is this clearly defined? Is it truly reasonable? Could it actually stand up if challenged in court? It's a really important question to consider.